Welcome everyone at the HR quarterly updates of Pallas Employment Lawyers. My name is Sanne van Ruitenbeek. I'm a partner and employment lawyer at Pallas in Amsterdam, and I'm here together with my colleague Julian Blok, also an employment lawyer. Today we're going to discuss various topics with you. We are going to start with updates on laws and trends we see in our practice. And we will have specifically attention for new rules, case law, and best practices on the topics non-compete clauses and employees and illness. Today we will also have 2 poll questions for you. During this presentation, I will ask your attention for 2 poll questions. We will discuss that together with the other questions you may have at the end of this webinar, so about 15 minutes we expect before the end. So if you have any questions during the course of our presentation, feel free to put them in the chat, and at the end of the webinar I will read them on the screen and we can discuss it by the end of this webinar. Furthermore, at the end of this webinar, you will receive a QR code, and we would like you to give feedback about this webinar and evaluate the presentation, the topics, and what else you would like to give feedback about. So be mindful that we would really appreciate that. Okay, to start with some news updates. Per the 1st of March, there is a new law which arranges subsidized mediation after a court referral. This is a measure because the government wants to promote mediation as an alternative dispute resolution. In our practice, we already see a lot of mediations in employment conflicts. However, usually it is before you start court proceedings, so it's actually to prevent court proceedings. In that case, you won't qualify for this subsidy, but if a court case already started, it may also be beneficial for you. So something to remember. Another thing which we see a lot in our practice is preparations for the act Working Where You Want. This law is still a proposal. It also has been amended in due time because it's already a proposal for quite some time. However, we do expect it to come into force sometime this year, even though with the new elections, everything's maybe unclear right now. Furthermore, it is important to at least already start with having a policy on the working location of your employees, but we see a lot of companies are already having that in place or working on it. Then it's important to notice that per the 18th of February, the Whistleblower Act came into force. So companies with 50 employees or more, or in a regulated sector, are obliged to have a whistleblowing policy. A lot of this has been explained already in a previous webinar. So if you have questions about this, look into the previous webinar we gave in the HR quarterly updates. In relation to this, we also want to flag that we see a lot of case law and with instant dismissal relating to transgressive behavior. So Me Too and other kind of transgressive behavior. So this is still quite a hot topic in a lot of businesses. And why this is also on this slide and close to the Whistleblowing Act bullet is that we see that a lot of policies on anti-harassment and Me Too prevention and speak up policies, etc., overlap with the whistleblowing policy, and it's not always fully clear which procedure is applicable in which situation. So we do advise you to put your policies next to each other and to see if they overlap or should be aligned to safeguard a proper process. And last but not least, we see a big trend in reorganizations and also employee retention on the other hand. So in our practice, we have many companies now requesting us to support with reorganizations because they want to change strategy, which also has to do with the limited capacity of employees on the labor market. And on the other hand, we see employee retention to retain the good employees or recruit the employees that should support your company in the best way forward. We will discuss reorganizations as well during our breakfast seminar. It's an in-person event in April. That will be an event in Dutch. So if you would like us to also discuss reorganizations in an HR quarterly update, please let us know in the feedback form, for instance, so we can take that into account and see whether we can address questions you have in that respect in an HR quarterly update later this year. Okay, then we're going to start with the non-compete clauses, and I'm going to give the floor to my colleague, Julien.
Thank you. And also a little bit in relation with what Sanna already mentioned about the retention of employees. We see an increase over the past period in cases with regard to non-compete clauses. We see more court cases, case law, but also questions from employers and employees if a non-compete clause can be enforced, and what the possibilities are for employees having a non-compete clause in their employment contracts. So therefore we thought that this would be also a good topic to discuss today. Also, again, as Sanna's already mentioned, maybe because of the current shortage on employees on the labor market, and that most of the times you see that when that's in place, non-compete clauses also become more and more important, and more questions come from that. Today I'm going to discuss with you with regard to the non-compete clauses, the general rules applicable, legal arguments for enforcement of a non-compete clause, especially from an employer's perspective, some recent court cases and examples, best practices, and developments with respect to those non-compete clauses. In general, the general rules to apply and to enforce a non-compete clause are, first of all, and not less important, it needs to be agreed upon in writing with an employee of legal age. And with respect to the first point, that the clause needs to be agreed upon in writing, that seems quite simple, but in practice you see that this goes not always in a correct way. For example, that in a previous employment contract, a non-compete clause was included, but an employee receives a new position, and only this new position is confirmed in a simple letter, no referral to any non-compete clause, or even that the non-compete clause is included in the letter. So then you have already a difficulty, that is the non-compete clause still agreed upon in writing. With respect to permanent or temporary contracts, there's also a difference. As of the 2015, there is a difference between the possibilities to include a non-compete clause in those different types of employment contracts. In a permanent employment contract, in basic, it's possible to include them. In temporary contracts, in principle, it's not permitted to include those clauses in the contracts, those restrictive clauses, unless the employer can substantiate why it is necessary to have this non-compete clause in a temporary contract for this specific individual. Also, and that motivation needs to be included in the clause as well, in the contract, because as you can imagine, if you have an employment contract for, let's say, 12 months, and such a clause is such a general clause is included in the contract, and an employee is then, after those 12 months, prohibited to work at a competitor in the Netherlands, that makes it much more difficult for the employee to be in the labor market and to find a new job. So therefore it's more strict already a couple of years. And it is also important to know that it cannot be a general substantiation or motivation why it is necessary in a temporary contract to have a non-compete clause applicable on that, in the employment contract for that specific employee. That is not courts do not agree with that, and those clauses will not stand in front of a court. So what will the court assess when you want to enforce a non-compete clause? Of course, is it in a correct way agreed upon? If the new employer falls under the scope of the non-compete clause, it needs to be, of course, a competitor. And do the interest of the employer outweigh the interest of the employee? And that is a very important question that needs to be answered. So if we take the view that a non-compete clause is indeed agreed upon in writing and legally valid, and a new employer is indeed a competitor of the former employer, then it is important as an employer to demonstrate that the new employer obtains a competitive advantage by hiring the former employee. So it is important that does have the employee important information or knowledge that is not present at the new employer, and does the new employer gain a certain advantage or competitive advantage when the employee is employed by the new employer. That is an important question that needs to be answered. And if that's the case, then is it reasonable to protect any accumulated knowledge or business relationships, clientele, specific products, or goodwill to protect the market position of the former employer? And then you can also think of more specific pricing of products, margins, product development, company strategies or sales strategies, discounts within the company, that is a discount policy, or specific agreements with suppliers. Those aspects or those specific information that needs to be taken into account. And the interest to enforce a non-compete clause cannot lie in the intention to bind an employee or to opposing competition in general within the market. But binding an employee is, of course, understandable that employers want to do that, but that's not the reason why you can enforce a non-competition clause. So as an employer, you need to be aware, and you need to take into account that the employee in question needs to be aware of important commercial and technical information of the company, and the new employer needs to have an unjustified competitive advantage by hiring the new employee, and that competitive advantage that information cannot be already available at the new employer. And that needs to be new information for the employer to create such a competitive advantage. So if you take a look at the weighting of interests between the employer and the employee, it's a little bit in line with what I just told in the slide before. So the employer has certain interests, and the employee, of course, has certain interests. And for the employee, it's important. Those interests can be the free choice of employment, of course, knowledge and experience within that the employee can gain at the new employer, chances of promotion, development, and wages as well, salary, or personal circumstances, for example, when an employee moves to a different part of the country. That could also be an interest for the employee that can be taken into account, or needs to be taken into account by the court. as I just mentioned, there were quite some cases over the past period, and also published cases with case law. I picked 3 different cases to also give you maybe a little bit of better understanding how what will be taken in consideration when eventually you end up before a court. In this case of the 17th of November of last year, the employer had a business within intelligence and data processing in the Netherlands. The specific employee was working as a junior business information and analytics consultant. Before that, she was employed as a trainee, but she was only working there for quite a limited time at the employer, and she was also working at a client of the employer, working as a business analyst and consultant at the client for the employer. The employee at a certain moment resigned herself, and good question the employee asked the employer was, when she resigned, she asked the employer to send her a list, because they agreed upon a non-competition clause, of course, in her employment contract, to provide her a list with the competitors. In this case, the employer provided that list, including the name of the company and the new employer she wanted to start working for. But we see that also happening sometimes in our own practice, that employers provide such a list when asked upon by an employee who wants to resign or wants to go to a new employer or a competitor. We always advise our clients to be very careful with sending such a list to an employee, especially if the non-compete clause does not give any reason to do so, because you also limit yourself or can possibly limit yourself, depending on how you how the wording of how you when you present that list, that you make it a limited list for competitors, and then possibly the employee can start working or will start working as a competitor not on that list, and then you make it more difficult for yourself if that's not necessary. In this case, that was not the situation, because the employee wanted to work at an employer on that list, and the new company she wanted to work for was established by former employees of the employer. That's also an important aspect in this case. The employee joins this company after some time, and then the former employer starts a court case because the employer wants to enforce the non-competition clause, and also claims a certain amount of money following the penalty clause applicable on the non-competition clause. In this case, the employer not made it sufficiently plausible that it has a special interest in maintaining the non-competition clause, because this employee had only a very limited amount of information and knowledge about the important business aspects or of the employer, the former employer, that the new employer would have a competitive advantage with by employing this new employee. She was only a junior business intelligence analyst, only worked for a very small amount of time at the former employer, and also as a trainee. So she didn't have any competitive knowledge, and in addition, because the new company was established by former employees of the company, the court also takes into account that any knowledge the employee already may have was already available at the company of the new employer, because of those other employees who were already started the company. And in addition, the employee made it sufficiently plausible that she will benefit from a transfer because of her salary increase and the possibilities to have any career developments and a career path at the new employer. So in this case, the employee could continue working at the new employer, and she didn't have to pay any penalties. Different is a court case of the 3rd of October of last year. In this case, the employer's activities were in the wholesale and construction, manufacturing industry. The employee's position was head of propulsion technology, and that is of course quite different than a trainee or a very junior employee. This employee worked already for several years at the company and had a lot of knowledge about pricing, margins, contract with suppliers, etc., etc. The employee was aware of those commercial and technical information, and therefore, in this case, the employer had the possibility to and substantiated that also in a correct way to the court that by hiring this new employee at the competitor, that they indeed would gain a significant amount of knowledge and a competitive knowledge, which otherwise they wouldn't have. So in this case, the court didn't annul the non-competition clause, and the employee needed to pay from the top of my mind 10,000 euros, a penalty of 10,000 euros, so quite extensive, quite a high amount. So it's not always that the non-competition clause cannot be enforced. You see that more and more the last period, that it is indeed possible to enforce those non-competition clause. A last court case, a very recent one of the 24th of February of this year. And this is, I wanted to discuss this court case today with you because of the importance to draft the non-competition clause in a very and pay attention when you draft the non-competition clause in a correct way. In this case, the non-compete clause included that the employee was not allowed to work for 12 months at a competitor in the Netherlands. As you can imagine, the employee resigned and asked the employer if he could work for a new employer in the Netherlands. And parties did not had a discussion if it was a competitor, yes or no, and the employer said no, you cannot work at that company because that's a competitor in the Netherlands. Then the employee started working not at the company in the Netherlands, but started working for the EMEA region at a legal entity and a company in Belgium. So the former employer, also started a court case and requested the court that that the employee immediately stopped his work and that he needed to pay a penalty. In this case, the court assessed that there was no communication about the non-competition clause because the former employer claimed that the non-competition clause was intended to protect the Dutch market, and that was the reason that he was not allowed to work at a competitor in the Netherlands. However, there was no communication with respect to that intention, and the court only took into account the language of the non-compete clause itself, and that only included that he was not allowed to work in the Netherlands. So despite the fact that he occasionally worked from his home in the Netherlands, the employee also made it sufficiently plausible that he was not working in the Netherlands itself, but much broader, and that a colleague of his new employer worked specific for the Dutch market. And the court also take into account that this employee pushed the boundaries, of course, what was possible. The court eventually decided that the employee was indeed allowed to start or to continue his work for the Belgian company, and that the non-competition clause, as included in his employment contract, was not able to be enforced in this case, and the employee could continue his work, and no, he didn't need to pay any penalty again. So, also taking into account the court cases I just discussed with you and the general rules with regard to non-competition clauses from our best practices, please take into account to tailor-made a non-competition clause linked to a position or to the business, that if you include a non-competition clause in an employment contract, and it is, of course, and so far as possible, that you make it as specific as possible. That saves a lot of discussions, possibly, when you want to enforce the non-competition clause. Maintain a strict and clear policy. So, and that is important because if you want to enforce non-competition clauses, you need to prevent any precedents in the past. So if you want to enforce non-competition clauses, especially for certain positions, then you should always do that, and not with specific employees you want to enforce them, and with specific employees you don't. Include a reasonable term. Best practice from our experience is 1 year, a maximum of 1 year. Have clear communication to employees when entering and leaving the employment. So when entering, make it clear that the employment contract indeed includes a non-competition clause. And when an employee leaves the company, make it clear also in writing that you will enforce the non-competition clause when the employee enters into employment with the new employer. And you can also, if an employee informs you that he wants to leave or she wants to leave the company and wants to work at a new employer, possibly a competitor, then you can always have a discussion with the employee to further agree upon a tailor-made clause when leaving, and that the employee is allowed to work at a competitor on certain conditions. And last but not least, payment during non-compete clauses. That also helps when you want to enforce the non-competition clauses, because employees have less arguments to say that the non-competition clause prevents them or unreasonably limits them in their income, etc. Again, it is not an argument to enforce non-competition clauses because of staff retention. Because I mention that again because you see that a lot in also still recent case law, that and always the court includes in those verdicts that is not a reason to enforce a non-competition clause. Then developments over the last year there was from the legislator a letter to the Dutch Parliament about the possibilities and the future of non-competition clauses, following from a research that has been done. And following that research, it became clear that there was a significant increase of the use of non-competition clauses from 2015 until 2020 or 2021, an increase from 19 to 37% of the Dutch working population who has a non-competition clause in their employment contracts. And also, even though there is as of 2015 there is it is more it's less easy to include a non-competition clause in a temporary contract, still it is quite easy to include such clauses, especially in employment contracts for an indefinite term. And you also see still that in temporary contracts, employment non-competition clauses are still included at the same amount as before 2015. So currently, employees should demonstrate why the employer has no legitimate interest to rely on a non-competition clause, and that limits the possibilities for employees, or makes it more difficult for employees, or more uncertain for employees to have some movement on the labor market. Therefore, there's a broad support base to change the rules on non-competition clauses. There, in the policy proposal sent to the Dutch government last year, there were 4 options to change the rules on non-competition clause, and those options include the maximum period of 1 year, only applicable if the employee resigns. That is, then only you can enforce a non-competition clause. Compensation if enforced. So then you need to pay a certain compensation if you want to enforce the non-competition clauses, or even a signing bonus if you want to include them in employment contracts, and always include a significant business interest, the same as now applicable for temporary contracts. In the letter from the legislator, it was included that they would further respond or get back to the government in the summer of 2020, but we are still waiting on that further response. So it's still unclear what is going to happen and which way or which of the options they want to further assess or make any new law proposals. So when that becomes more clear, we of course let you know any further. Sanne.
Yes.
Your turn.
Thank you. Okay, so yes, indeed, we'll wonder what will be done with the non-competition clauses. I have to say that from a European perspective, we are quite employer-friendly in terms of non-compete clauses, so that may also be a reason to be a bit more strict, but we should see whether that eventually will happen or not. Before I will start with my employees and illness presentation, I want to inform you that between now and a minute, you will receive 2 poll questions in your screen, or at least that's what we would like to happen. You can answer those poll questions. One is about the non-compete enforcement. One is about how you perceive working with the company doctor, if you have any experience with that, which relates to my presentation. And after my presentation, I will see the outcome on my screen, and we will go into your answers. Answering these poll questions is anonymous, so you will not see your name. You will just see how many of you, the percentage of you answered A, and how many of you B, C, or D. So in that sense, it's anonymous. But we would like to see what your experiences are. So let's see if this works with these poll questions. Okay. Then the next topic, the employees and illness. I will discuss with you a legislative proposal which is still pending. I will discuss 3 case law topics, so 3 court decisions which relate to different issues with ill employees, and share some best practices, because we get a lot of questions about illness in employees and how to deal with this. Okay. The legislative proposal. There is a proposal to amend the VIA, which is the Act about Long-Term Illness. This is already a proposal for, I think, 2 years now, or maybe even longer. And it's pending for a long time, also because of interim elections, etc. But in the beginning of February of this year, the process has been resumed to discuss it in the Senate. And why is this relevant for employers? Well, this bill is expected to decrease the sanctions of UWV after 2 years of illness. Because then the company doctor judgments will be leading in the UWV assessment of reintegration report of the employer. So as you know, when an employee is ill, you will have to continue to pay the salary for 2 years. And after those 2 years, you will submit a report and reintegration report to UWV, who will assess if you've done your work as an employer, if you've met your obligations to support the employee with reintegration, etc. And what happened often was that the UWV said, well, we don't agree, or our doctor doesn't agree with the company doctor, so you could have done more in terms of reintegration, and therefore we reject what you've done, and we sanction you by ordering that you should pay a third year of the employee during illness. And that was, of course, very frustrating for employers because they were no doctors themselves. The only thing they could do is rely on their own company doctor. So what should be an improvement with this new law is that the employer cannot be disadvantaged anymore due to a difference of opinion between the company doctor and the UWV doctor. And therefore, the employer can rely on assessment and advice of the company doctor. We also hear a lot of arguments from, for instance, the public sector not to agree with this law, for instance, because then, like private doctors, have something to say which could have an effect on public benefits. But I also think that the current situation where an employer doesn't know what the outcome will be and just try to do its best is a risk as well, and is also not completely fair. So it would be good if at least something happens with this. I see the poll questions are coming in. Great. Okay, then I will discuss two case law questions, case law topics. So then the first one, this was the Court of The Hague, very recent, of the 10th of February, and is about termination due to long-term disability. So this employee was employed by a school, and after 2 years of being 100% ill and no reintegration took place, the employee received a VIA benefit, a high benefit. And the company doctor said in its estimation that the company doctor wouldn't expect recovery within 26 weeks. And you need this statement as an employer to be able to file for termination at UWV. But thereafter, the employee asked a second opinion from a doctor as well, and that doctor said that recovery was expected within 26 weeks. And therefore, UWV rejected the termination request of the employer. The employer didn't agree with this and appealed the decision of UWV by going to court. And the court overrules this second opinion with a statement that it's inconclusive. Because if a second opinion deviates from the initial opinion, you do have to substantiate why. And the substantiation was not clear enough, and it was also not completely logical according to the court. And therefore, the court decided to terminate the employment contract and grant a transition allowance to the employee. And as you know, these kind of transition allowances can be charged at UWV. So that was not so much a disadvantage for the employer, and it was a success that the employment contract was terminated after those 2 years, or at least it was already longer than 2 years in the meantime. So what we can learn from this is that sometimes there is an unfair, or you feel as an employer there's an unfair outcome at UWV, and you do have to know that courts often, there's quite a chance of success if you go to court with a case, because they look at these cases differently. Okay, then the Court of Appeal in Amsterdam on the 20th of December of last year. It's about vacation days of sick employees. This employee was an employee of ING Bank and was long-term ill. And the employee wanted to take vacation days, which were already accrued before the start of the illness. And ING didn't want to pay the regular salary during those vacation days, but only wanted to pay the supplement to the VIA benefit, because this was already the third year of the illness, but the employment contract was still in force. So under the policy of ING, even when you get the VIA benefits, you are already for more than 2 years employed, ING supplements by this benefit to probably your base salary level. And ING said, well, we're only paying that during those vacation days. The first court and the Court of Appeal disagreed with ING and said you have to pay the full salary during vacation, because that's the value of the vacation days. And even though maybe not a lot of you have this third year of illness supplement, because that's usually part of collective labor agreements and not all of you have that in place, it's still important to be aware about vacation during illness, because what we see is that this doesn't always goes the right way. Vacation during illness always means that you will have to pay the full salary during the vacation days of an ill employee. And it also means that you should deduct a full vacation day. So even if the employee has 70% of the salary during vacation, you pay 100%. And also, even because the employee only needs to work 4 hours in a day because of reintegration, if the employee takes a vacation day, you deduct 8 hours if that's the regular working hours, if the employee takes a vacation day. So that is important to take into account, because we see a lot of mistakes in practice about that. Okay, then the Court of Haarlem of November last year. This is about wage suspension and wage stopping. That's also what we see go wrong a lot of times. So therefore this court judgment. This employee is a recruiter. And between the end of May and the end of June, the employer stopped payment of the salary because the employee was unavailable for the company doctor. There was a meeting scheduled with the company doctor. The employee didn't show up, or didn't answer the phone, actually, because it was a telephone call. And the employer resumed the payment again once the actual company doctor, a new meeting took place. And again, later in July, until the 1st of September, the employer stopped paying the salary again because of the fact that the employee didn't comply with the reintegration advice. So the company doctor advised to be able to do some reintegration work, and the employee refused. Then the employee resigned and went to court to claim payback of wages. And because the employee felt that the wage stops were unlawfully applied. So the court looked at the case and he said the second wage stop was lawful because indeed the employee didn't meet the reintegration advice activities advised by the company doctor. But the first wage stop was unlawful because this should have been a wage suspension. And there is a difference between a wage stop and a wage suspension. Suspension means that you stop paying, but once the employee cooperates again with going to the company doctor, you repay the wages you withheld. So you pay with retrospective force. That means actually the measure is not that strict because you stop paying, but once the employee goes to the company doctor, you should pay the full salary you stopped with retrospective force. So it's important to understand this difference, because we see a lot of time that employers put in their letters, we suspend the wages. But if you say that, that means you will have to repay it when the employee cooperates, and you cannot have just a wage stop, which is possible if the employee doesn't comply with reintegration advice. Okay, then what are the key takeaways and best practices from this part of the presentation? Encourage your employees to take fully paid vacation days to prevent large accruals. So they are fully paid, but at least they are taken, and employees can take vacation days while they're ill. It's usually easier to encourage them to take it when they are reintegrating and taking a break from that than when they are fully ill. But it's important to look at it. Be keen on the difference between a salary stop and a salary suspension. And we can, of course, support you with that in specific cases. Appeal in court if UWV really has an unfair decision or is unjustified according to your opinion. Then we would say intervene. That is a best practice. Intervene when employee report sick because of negative performance feedback. Of course, we see that a lot. Employee gets negative performance feedback, will be put on a performance improvement plan, but before even you can start, the employee reports ill because of a work-related conflict, etc., which makes it very difficult to start working on the performance improvement. Company doctors should, in principle, see through this, but they also need to be informed by you and understand the situation. So it's really our advice to build a good relation with your company doctor and speak to the company doctor to inform the company doctor about the situation and about the negative performance feedback before the company doctor talks to the employee, so the company doctor has heard both sides before he drafts his report. And lastly, a settlement on termination can be a solution, especially if it concerns work-related issues. So if the illness is related to the work and therefore the work itself prevents the recovery. Of course, you always need to check in terms of settlement if there is a big risk for the employee of losing Social Security by agreeing with a termination while being sick. But in our view, it's not always necessary to await full recovery before you can agree on a settlement on termination with an employee, because there are ways to look into it, for instance, to set the end date in the settlement agreement a little bit later, so the employee has time to recover and involve the company doctor in that process. Okay, then I will go to the poll questions. Let's see. The question about the illness. So, are the advices of the company doctor in general helping in the progress of the illness case? Well, 43% says yes, 29% says no, and 29% says no opinion. And I see now one coming in for A. So a lot of people think that the company doctor advices are helpful. Well, that is of course good. Even it's not a very big difference. What we see a lot is that company doctors can be very helpful and clear in their reports, but we also see often, especially when it's work related, that the company doctors stay a little bit vague. And then it's unclear whether the employee can already start reintegration if the work conflict is still there, and that then therefore the employee refuses to start to work, doesn't really cooperate with helping to solve the work conflict, and then you get a bit of a deadlock. So there we see the difficult situations, and also sometimes that the company doctor feels it's they seem to be a bit scared to be clear in their advices. But it's good to see that a lot of you still think that the advice help from the company doctor and work on the progress. Okay, then the second question. We usually enforce the non-compete clauses of our employees. So 43% says yes.
Okay.
And 57% says no. So, and then the other not applicable and unclear have 0%. So I think it's about 60% no, 40% yes. So a little bit more than the majority will not enforce
them. And then you can still ask the question why, if you want to include those non-competition clauses in the contracts, if you don't gonna enforce them, because then as I already told, if you don't gonna enforce the non-competition clauses, even though you include them in the contracts, then that may create a precedent, and then you can maybe think of a better solution to really think if you want to include a non-competition clause in an employment contract for specific employees or specific positions, and include them in at that time in the employment contracts, and if that employee then leaves the company, that you want to enforce them at that time, and then it is again more tailor-made, and you don't create a precedent because you included only the non-competition clauses in the contracts of the employees you really want to enforce them, and then it's also logical that you gonna enforce them instead of just including them as a sort of standard or a template and not going to use them as well. So and that's what we also see a lot in practice, in our practice.
Okay, thanks. Then we go to the questions you asked in the chat. You can still place them if you have some. I will go to the first one. It's here in Dutch, so I will translate it in English. How should we deal with vacation days accrued in the period when the employee is ill and you pay only 70% of the wages? So the question is about, is the accrual during the period that the employee is ill and you paid not the full salary, different than the accrual of the vacation days while the employee was not ill? Well, there is actually no difference. So the employee accrues the same amount of vacation days during illness. So yeah, there is no, and if the employee takes vacation days, you pay them for 100%. So that is a bit strange, maybe, but that's how the rule works. Okay. Yeah, I also have a question, like in some sectors, for instance, here I see in aviation, it is difficult to enforce a non-compete, especially in this economy. Difficult in this work economy. I think, or it's either to put them in the contract, because then you won't get the employees. If you put a non-compete in the contract, then the employees won't sign the contract.
And on the other hand, again, it's also the weighing of interests. And I can imagine that maybe in the aviation, in which you are a pilot and then you can fly a certain aircraft, the interests of the employee to also be employed by a new employer or another employer after the employment contract with the employer, that can be taken more into account than maybe the interests of the employer with respect to competitive advantages of the new employer. Also with maybe specific case pilots, you could also ask the question how much business knowledge do they have about pricing,
so what does it actually affect you when they do enter into employment with a competitor? Exactly. Okay, another question, not related to absence, but that's fine. But is it very easy to end a fixed term contract early, so before I think the end of the expiration date, when there is a good financial business case? So the question is actually, can I internally terminate a temporary contract for business reasons? It is possible, especially if you have a clause in the contract which allows interim termination, which is not always the case, so important to check that. And if you have a good business case, it means valid business grounds. For instance, if the position will be made redundant because you don't need the position anymore because you changed your business, then that is indeed possible. But if the employee doesn't agree, you will have to go to UWV to ask for a termination permit, and UWV will assess then whether you have a valid ground. So if you only have like 2 months to go or something, it's not really worth going into these proceedings, maybe, because the UWV proceeding usually also takes about 4 to 8 weeks.
Yeah, but the first question is there such a clause included in the employment contract to terminate the employment contract prematurely?
Yeah. Yeah, I think the question about the non-compete is a bit more specialized to, for instance, if it's about engineers with a specific certificate, and then they say they can find a job everywhere in aviation. Well, if it's easy to find a job everywhere in aviation and also at an aviation company not competitive to yours, that's an argument for you as an aviation company to enforce the non-compete. Because then the employee can easily also work in aviation at a non-competing company. Because of course, not all aviation companies compete with each other. It also depends a bit on your on the sector or on your specific activities.
If you have only personnel, you fly with people instead of cargo, then there could be a difference.
Yeah.
For example. Yeah.
Another question here is about, let's see, is it still common that companies pay 100% of the salary during illness? Well, if you are covered by a collective labor agreement, we still see a lot of times 100% payment. Often in the second year it decreases to, for instance, 70%, but we do see 100% also there. For the international companies coming to the Netherlands or the smaller companies, we do see this differently. So we do also see that 100% is paid in the beginning, but this is not a full year, but for instance, 3 months or 6 months or 9 months, and then it drops to 70%. So we see this differently being treated within companies. It's not like everyone, and also not mandatory to have 100% for the first year. And then the last question. If employers pay the employee a compensation during the term of the non-compete, how high is that compensation usually?
Yeah, from my practice, the compensation normally is that you take into account the base salary or the base salary, that you take that into account for a certain amount of time or for the whole period of the non-competition clause, and that could be maybe less than 100% of the salary, including additional compensations or variable bonuses or something like that. That is, from my experience, practice.
Yeah, we also sometimes see indeed that the base salary is like the starting point, but if the employee has alternative income, like for instance unemployment benefits or a new job, that income is deducted from what the employer will pay. The former employer will actually pay like a supplement to that to make sure the employee has sufficient income. But of course, that requires quite some administration, which is not always very practical for the former employer.
Yeah.
Okay. Well, those were all the questions you've asked. I hope you have enjoyed this webinar and you've learned something from it. Any suggestions you have, please feel free to share these in the evaluation form. Please scan the QR code and give us feedback about this, and also share the topics you would like to see in the webinars.
And of course, if you have any further questions, just contact us and ask them.
Exactly. We will share the presentation with the participants. Our contact details are in there as well. Please feel free to email us if you have anything we can support you with. Okay, this was it for today. Have a nice day, and we hope to see you soon. Thank you.